The Alexander case is on page 8. Good morning, Your Honor. Natalie Snyder on behalf of the state.
Good morning, Your Honor. Alon and Oren Alexander on behalf of the Alexanders.
And Dr. Streyffeler is on Zoom. Good morning, Dr. Streyffeler.
Well, can you hear me? Good
I
morning.
can hear you. I can hear you.
Okay.
So let me go ahead and swear you in the event that you have to give testimony. Do you swear or affirm that the testimony you're about to give shall be the truth?
I do.
Thank you. All right, I'm going to talk to the lawyers first, and
Okay.
then we may have to inquire from you. So it's your motion. They're opposing it. She's here in the event that she has to testify as to her work, and I also think her credentials and her work.
Correct, Judge. And I can go ahead and elicit that testimony now. We have not been able to reach an agreement. So if I may inquire of the witness, Judge. Good morning, Dr. Streyffeler.
Good morning.
Would you please state your full name and spell your last for the court reporter?
Laura Kopelman Streffler, Streyff like Frank, Eler.
And you are a doctor.
Yes, I am a PhD
Okay. In what?
in human services
How long have you been a doctor of human services?
since 2008, and I've been licensed as a mental health counselor since 1998.
Tell us a little bit about your educational background.
I received a bachelor's of science in media communications and economics from Worcester State College in Worcester, Massachusetts. I received a master's in mental health counseling from Nova Southeastern University and a PhD from Capella University in Minnesota.
And tell us about your work since you received your doctorate throughout your education.
You said the doctorate was in what?
The doctorate is in human services. I was already licensed as a mental health counselor, and a great amount of my work was working for not-for-profits.
So tell us a little bit about your career.
I started back in the late 80s working in a domestic violence shelter, volunteering initially, going to hospitals where there were victims of domestic and sexual violence, doing on-site at the hospitals. Shortly thereafter, I was hired by the Domestic and Sexual Violence Center. I worked as a residential crisis counselor in the shelter, and I continued to do on-call to the hospitals. While I was getting my master's, I created a program for teenagers arrested for domestic violence in their families, and I facilitated that here in Lee County, Florida for about 5 years. I was also the adolescent outpatient director of that same agency. In 2000, I had a son and no longer wanted to work late at night, so I went back to the domestic violence shelter, abuse counseling and treatment, and as the clinical director, and I foresee all the clinical programs of the domestic and sexual violence. At that point, we were also doing things with victims of human trafficking and worked with victims of human trafficking. I went into the jails and worked with both the men and women of victims of domestic and sexual violence. Doing educational programs. I also was doing trainings. I've done trainings for the Lee County school system, for law enforcement, for the Department of Children and Families. I also had done, I had also done in-home for child abuse and neglect. I have been credentialed as an expert in family violence through a Daubert hearing or Daubert hearing. Let me think. So I went back to the.
I'm sorry, you said licensed in-home.
No, I'm licensed in mental health counseling. I did do in-home for child abuse and neglect through the Family Preservation Program. I spent 8 years on the fatality review team. I taught domestic violence and the criminal mind at Florida Gulf Coast University for a number of semesters. I wrote a program and taught for Hodges University for their master's in mental health counseling. I wrote a trauma program. I don't know. I've been doing private practice since 2012. I was doing private practice because up until about 10 years ago, trauma wasn't something that a lot of the mainstream mental health counselors were trained in and dealing with, especially domestic and sexual violence. And I've also done expert testimony in the dependency court for the guardian ad litem program. I've done civil, I've done criminal, I've done a lot of family. I spent years in juvenile court. I've done, I think, 3 or 4, I'd have to look, battered spouse syndrome cases. Some actually were for the state, and some were for the defense, depending on whether or not I believe the case met the criteria of I believe it was 4 that I did, only 1 actually met the criteria.
So, Doctor, I know you mentioned you were the clinical director for quite some time. Of what
10
program was
years.
that? I'm sorry.
I missed you. I'm sorry.
You were the clinical director of what program in Collier County?
It wasn't Collier County, it was Lee County. Abuse
Okay.
counseling and treatment.
Okay, and tell us, is that, I know we have a rape treatment center down here in Miami. Is that the equivalent of the rape treatment center?
Well, yes and no. Abuse counseling and treatment has a domestic and sexual violence shelter in Cape Coral, in Fort Myers, and in there's also one out in LaBelle. They also run the Rape Trauma Center. When I originally started doing things for the Rape Trauma Center 150 years ago, which really was almost 40 years ago, I've been doing this almost that long. We went to the hospital. There was no physical facility, but the agency did it. And then for many years, there was a house that was used where law enforcement came, where it was more comfortable, across the street from the hospital. And the Rape Trauma Center was there for a number of years. And currently it's behind the domestic violence shelter and the administration building. They do both residential and non-residential services at the agency.
And what was your role as clinical director? What did you do specifically?
I oversaw all the clinical services. Some of the counselors were more advocates. They didn't have advanced formal education. Many did, especially when I came back as clinical director back in the day when I started. That wasn't as true. I supervised a number of clinical interns from Florida, Gulf Coast University, as well as a number of other local colleges that wanted to get clinical experience in the shelter. I oversaw any subpoenas or court documents that came in. Very often I went to court with clients. I unfortunately a few times had a Baker Act clients. I personally saw a number of clients. Usually the clients that I saw had been through very egregious, horrific, I mean, it's all egregious and horrific, but life-threatening trauma and sometimes with family members, where a daughter or I'm thinking of one specifically, there are a couple with a daughter or a sister that were killed by their partner, and worked with the family members and went with them to court and helped them process the trauma. I also did that for a number of sexual violence, rape survivors. A lot of times, unfortunately, I had to work with rape survivors who had been brutally assaulted, but they didn't have the proof or the evidence, and there wasn't enough to show. So I had to explain, the difference between somebody being able to, whether or not somebody believed you or it mattered, or whether or not they had the evidence to make it to win in a court hearing what they needed for a conviction. And that was very difficult because for a number of survivors, the charges weren't, even after they came forward, there wasn't enough to press charges. But just because you can't prove that it happened doesn't mean that it didn't happen or that the trauma is any less.
So Dr. Streyffeler, how many patients have you worked with who were survivors of sexual abuse? If you can estimate.
Thousands. I've worked with many victims of incest, both parental or parental figure or guardian, sibling incest, sexual child abuse, sexual assault in college, and then they're later in their adults, until Me Too. The average age of somebody reporting sexual assault for the first time was 52. But because that was a safe environment, and because of my knowledge and being able to kind of read the signs, I was able to work with even clients who came in maybe for domestic violence or for other things, even in my private practice, where we were working through sexual assault as well, even though that's not why they originally came in. I worked with literally thousands, both right after the assault, in the emergency room at the Rape Trauma Center, right after in the domestic violence center or domestic sexual violence center in my private practice, or even some 40, 50, 60 years later, literally 60 years later.
So you have testified, you said, as an expert before.
Yes.
What rates do you typically charge at this point in your career?
At this point in my career, I charge $300 an hour for deposition or court, and $400 an hour for deposition and court.
Okay. And how did you get to that particular amount of money per hour?
Well, I was charging about $50 less than that. I don't for a long time. And 2 years ago, I was in court, and there was a gentleman that was testifying that had nowhere near the experience that I did. Well, we'll just leave it at that. And he was charging $400. So I went back and I looked at the rates, and they're between $300 and $500 for a lot of the paperwork and non-court related work, and much higher for depositions and testimony. Some of them go up.
Hold on, doctor.
I'm just gonna get her testifying about what other people's rates are.
Isn't she allowed to testify about comparable rates for other professionals in the area? That's the way that I take it. Okay, so your objection is on hold. You could finish your answer.
And then I did some research. I don't go looking for private practice cases. People very often, because this is really more of a niche area, and there aren't a lot of people with the academic background that I have, as well as the domestic and sexual assault piece. A lot of times with those cases, people will contact me, and quite honestly, I turn down more cases that I take than I take, because it's really just about telling the truth, and I'm able to see things because of the amount of experience that I have, in addition to my scholar practitioner background. And quite honestly, I've been doing this a really long time, and I'm very knowledgeable, and I think that my education and my experience and my integrity are worth the money.
So as far as the $300 for non-court appearances and the $400 for court appearances, is that what you're charging in these cases involving the Alexander?
Yes,
And is that what you're charging the state as well as defense?
yes, I would, in fact, the fact that was, I believe it was was it three? Let me look, I believe, because quite honestly, I haven't, that one, I was at 3 or 350, it was at 350. I don't, I'd have to look what it, I apologize. I believe it, when you said 3, I thought you had it in front of you. I thought it was 350.
It's 354.
Say it again.
What is it 354? Tell me about
For non-clinical, non-court related, like reviewing, time spent that's not deposition and not court.
understood. So it's 350 for non-deposition, non-court,
And then
and
400
for court
deposition and court.
appearances.
Yes, and that's,
Okay.
and that's the exact rate the state is paying. And quite honestly, I was offended, for a lack of a better word, that there was an implication, especially after a year of no response to a bill and not paying a bill for a year. I can't imagine that the defense would keep a client that didn't pay for a year and never said anything. And that I was offended that they would say, especially where I talked about the importance of integrity in my deposition, that he would infer that I would charge him a different rate just because the clients have money, that I would charge a different rate to him than I did to you. I found that very offensive.
And you said that you charge 350 for non.
Let me look. I have to, I apologize.
I didn't hear. That's why I'm asking. I didn't hear. I heard the 400 for court. What was the non-court?
400, I changed the, I thought it was 350, but when she said 300, I thought she had it in front of her, and I didn't.
No, I think it's 350, Judge, according to the bill that is
I
attached.
just didn't hear.
I thought it was 350, but when you said,
So,
I
I'm
didn't really
gonna-
hear you.
I'm gonna limit your testimony. I know you're taking it personal, but the speaking about how offended you are, that you have this integrity, all of that isn't necessary at this stage. Okay, doctor?
Okay.
So, all right, you can continue.
So, Doctor, I know there's been some claim that you have worked for Jack Rates in the past. Have you worked for Jack Rates in the past?
Many, many years ago, I did, yes.
Okay. Have you recently worked for Jack Rates?
No, I believe the last time that I did it, I can actually tell you, I did an evaluation. I did do an evaluation in 2020 of a gentleman, and I did agree, and that's the last time. So it's been 6 years since I've
Okay.
worked with Jack Rates.
In this case, you were deposed on June 4th, 2025. Is that correct?
Yes,
And you were deposed for approximately 4.5 hours.
yes,
And then you added travel to that in your invoice. Is that correct?
yes, I was out of the office. I had to be out of the office.
Okay. Defense has also claimed, is your office very big?
Is my office very big? No.
I think there's Okay, I think there's been some claim that we could have done the deposition at your office. Is it big enough to hold the number of people?
Yes, that was never discussed.
Okay.
No, but she's asking you, is your office large enough to hold,
4 or 5
X amount
people, absolutely, yes.
how many people is your office able to hold?
I have a large size a decent sized waiting room, and then I also have another room where I see clients.
But where would the deposition take place in your office?
It probably would have to be in the waiting room. I would have pulled chairs, but they I don't recall they said that it was gonna be at the with the stenographer, I can't think of, the court reporting office.
Do you have a separate conference room in your office?
I don't have a conference room, I have a waiting room.
Okay, so it's a waiting room in your office.
Yes, I've never done a deposition in my office, ever.
You can continue.
Thank you. Now, you first sent your invoice in this case.
I can't hear you.
It's okay. Let me speak it to the microphone. I'm sorry. July 8th, 2025 was the first time you sent an invoice in this case. Is that correct?
Let me look at that. I printed them out so I could see.
I'll reject the vague. Who did she send an invoice to?
Can you tell us who you sent an invoice to in, what date was that?
July 8th, 2025.
I had sent the invoice to you, Natalie Snyder, originally, and you had sent it. I did not, at that point, I had asked you how you wanted to do it. I didn't have the attorney's contact information, and you had told me that you would forward it to him, and that you had, and I know that you had done that.
And then you did send some follow-up emails and eventually you followed up with the attorney directly. Is that correct?
Yes, yes.
Okay, and that I believe was,
I'm gonna object to what attorney? She never contacted.
What attorney did you,
we have an email. I have it.
I sent the attorney, I had asked Natalie for the attorney's direct email. And I had sent it directly to the office.
so the question is, which lawyer specifically did you contact?
I wanna, let me just check. My internet went down this morning when I was printing this stuff out.
Judge, I have a copy of it. I kind of forgot.
If she has it, yeah, my internet went out, so I was printing these out this morning so I would have them, and I lost my internet.
Judge, if you want to give me a second afterwards, I'll look it
Sure.
up. Did you ever hear back from defense?
Never of any of the, no.
Okay, so anything that you sent, you did not hear back.
Correct, and I believe from memory, it was sent to more than one attorney at the practice.
Okay, so I'm gonna get that information. I have no further questions.
Okay. Let me see if the defense has any questions for you.
Yes, Your Honor. Thank you. Good morning, Dr. Streyffeler.
Good morning, could you talk a little bit louder?
Sure, can you hear me?
I can now.
Okay, great. So you and I have not, my name's Ed O'Donnell. You and I met at the deposition, right, with Miss Snyder and I, and there was a court reporter?
Yes.
Okay, and we attempted to see if we could take the deposition in your office, and we were informed, I think by somebody, I don't know if it's Miss Snyder or whatever, that we couldn't because your office was too small. Is that right?
I don't recall that. I'm not
Okay.
saying you're incorrect. I'm saying I don't recall that.
Okay, well, yeah, we have an email to that effect. We can get it. I don't know exactly who it was from, but it doesn't matter. So in other words, because we couldn't take it at your office, we had to get a conference room that we paid for near your office. Is that right?
Yes,
Okay. And before we took the deposition of you, when I say we, I was there in person and there were some other lawyers by Zoom. You had never spoken to myself or to any other attorneys. Is that right? Defense attorneys, correct?
that is correct.
Okay. And you never sent your billing rates or your hourly rates to us, did you?
They were never requested and they're pretty standard. I've never
Okay.
been asked prior to a deposition. I've never been asked my rates.
Okay,
by
so
the other side.
so just so we're clear, you never sent us your rates for the depositions, is that correct?
That's correct. And it's also correct. They weren't requested and there was no comment after the invoices were sent.
Okay, so when you say they weren't requested, you mean they weren't requested by the defense?
Correct.
Okay. And just so we're clear, no correspondence from you was ever sent to the defense or to Ms. Snyder about how much you planned on billing us for taking your deposition.
The information was never requested.
Okay, are you aware that the defense in an email requested that Ms. Snyder
I'm going to object to mischaracterization of the email that was sent.
Overruled. Let's hear the question.
are you aware that the defense, before we had to hastily take your deposition, requested what your compensation rates were? Are you aware that we asked Ms. Snyder for that information?
Ms. Snyder has that information. My rates for you are the same as my rates for her.
Okay, we'll get to that. Okay, but just, are you aware that we asked Ms. Snyder?
They admit the email that they're referring to because I believe there was a laundry list of questions, not asking for deposition rates. And I think that it needs to stand for itself. No one's ever asked for specifically deposition rates. So I do object. If they're going to refer to a document, I ask they admit it.
Can you show her the document? Is there a way to?
I've seen it, Judge. I've seen it. It's a laundry list of questions.
If I sustain your objection, how does he show her the document?
I mean, I don't
Because you're
think
saying.
he has any personal knowledge of this, Judge. But I think that Your Honor can see for yourself what this email was, that it's a laundry list of questions, mostly not having to do with any rates. And
So you're trying to impeach her.
No, I'm not trying to impeach her. I'll be glad to move it into evidence. In fact, I'm going to read, if I can read it in right now, Your Honor.
So your question is she familiar with what you're about to read into the record? I think that's the question, right?
Well, I asked her if she was aware that we asked Ms. Snyder for her rates.
And I object to the characterization of the email in front of them because they ask for a number of things, her rates generally, but not her deposition rates. So again, they're asking what she's an expert of, what she's what she's going to be testifying to. They basically want a deposition is what it looked like.
Understood. So your question to her is again, did she ask, go ahead.
Did Ms. Snyder ever ask you what your rates were going to be that you were going to charge the defense?
I don't recall. Again, the rates were originally sent to her and she had the rates. I don't remember having another conversation about rates with her.
So your testimony today is that you told Ms. Snyder what your rates were for the deposition and that Ms. Snyder was aware of what those rates were.
No,
That's
no,
your testimony.
That's not my testimony. My testimony is that she asked what the state rate, what my rates were, and I sent her those, and I don't recall having a conversation about my deposition rates because they weren't a whole lot different. I don't recall, again, we're talking a year and a half ago. I don't recall a second conversation because the defense never asked my rates. The only conversation I recall was regarded numerous moving around the dates and when I was available.
Okay, you were listed as a deposition. I mean, excuse me, you were listed as a witness about 2 weeks before a trial date, right? You're aware of that?
Yes,
Okay. And you were listed by Miss Snyder as an expert. Are you aware of that?
yes,
Okay. And you were aware that we were trying to take your deposition in time for a trial that was set in stone 2 weeks from the day you were listed. You're aware of that, right?
yes,
And you're also aware, doctor, that we were trying to find a place to depose you near your office since we couldn't do it at your office, right?
I recall being told that it likely was gonna be at the stenographer's office, and generally that's where I go for depositions. I don't recall there being an issue with my office not being available. It may not have been the most comfortable. I don't have a conference room, but I don't recall it being an issue that not being here. It may have been discussed that that either you or the people would be more comfortable someplace else, but I don't recall it being an issue that we could not have it here. I recall it being an issue more of comfort, but it wasn't really a discussion. It may have been mentioned. If I knew it was an issue, I certainly could have made accommodations. I have the room to make accommodations.
Okay, we'll get to that in a little bit, doctor. So you were aware the purpose of us coming to your county, wherever it may have been, was to take your deposition because you were just listed on the eve of trial, correct?
I was absolutely aware of that.
Okay. And have you had a chance to read your deposition that we took that day?
I got it yesterday.
Did you have a chance to read it?
Yes, I had a chance to scan it.
Oh, okay. And it's a fact that when Miss Snyder listed you as a witness, that, well, let me step back a second. You said that you provided the deposition rates to Miss Snyder. Do you know if Miss Snyder gave us the courtesy of knowing what those rates were?
I don't know.
Okay. How did you provide those rates to Miss Snyder? Did you orally tell her or did you email her?
When she originally asked me what my rates were, I sent her the rates
How did you send her the rates?
in an email.
Okay. And what rates did you send?
I sent the $350 and the $400 rates.
Could you please, do you have access to that? Do you have access to the email you sent Miss Snyder? Or does Miss Snyder have that email?
I have to look. I switched email providers, so I don't have all my, I can look for it. Ms. Snyder, do you have a copy of the initial email that I sent you?
I do. I don't have a date, Judge, and I will say that she did send me her rates. Yes, I asked for them and she sent them.
And what is the date that you sent them?
She doesn't know the date.
Can we get a copy from Ms. Snyder of that email?
Is it discoverable?
I don't see, I mean, they have all of my public records, so I'm sure they have them. But Judge, I don't know that it would necessarily be discoverable. I mean, I can send it as a courtesy. I just can't access it right now. I'm going to have to supplement.
Okay, you don't have it in all the public records requests you did under.
They don't exist. And if they existed, we were told by Ms. Snyder, we'll find out what her rates are when we go to deposition. We have that in writing.
Judge,
Yeah.
I would like that
Yeah,
email to be
what-
admitted because she keeps referring to it. It's not what it says. If you look at the laundry list of what they ask, it's very clear that they wanted me to write out a proffer of what her testimony would be. I objected to that.
Absolutely. Can
It
I?
asks for rates, but more in the context of like, what are her rates? What does she charge? Not what are her rates for deposition or what are we going to be charged? So I want to just make that very clear for the record because they keep going back to that. They keep misrepresenting what's in that email.
Can
And
I-
I would like
I'm
the
gonna
judge to
see
see
the
it.
email.
Absolutely, Your Honor. In fact, we attached it to our motion, but if I could just read it, because I think it's going to be relevant. On May 17th at May 17th of 25 at 4:43 PM, Mr. Sloman, with all of us on the group, all the lawyers on the group, Natalie, please provide us with the subject matter on which Dr. Laura Streyffeler is expected to testify, a summary of the facts and opinions as to which she is expected to testify, along with the grounds for each opinion, comma, the compensation for her services and her litigation experience, including the percentage of cases which she has testified for victims of sexual abuse. So that was at 4:43 on May 17th. And Ms. Snyder had just listed Dr. Streyffeler as a witness. And Ms. Snyder responded, let me see.
You are welcome to depose her. I have provided everything I'm required to provide under discovery rules. She did not write any reports.
So Ms. Snyder did not tell us what Dr. Streffler's rates were.
It's not a time for argument. Do you have another question for Dr. Streff, for the doctor?
Yes, but I think that is relevant, Your Honor, to us being put on knowledge and the reasonableness. In light of the fact that Ms. Snyder apparently had those rates, we have not been provided them, and I do believe we are absolutely entitled to them.
Is there
But
another follow-up email to what she gave here,
No, Judge.
that the state gave?
Judge, as far as I know, no, but I know that was the end of it. We were told, go depose her and you'll find out whatever you want from her. And remember, she was listed 2 weeks before. 2 days later after this email, Dr. Streffler's listing as an expert was updated and they removed her from care of the state and put a Fort Myers address requiring us to, obtain service, that way. So, Dr. Streyffeler, in your deposition, you were asked if you provided Ms. Snyder or discussed what your rates were and your compensation for any of your work, and you said that you didn't ever discuss it with Ms. Snyder. You aware of that?
I would have to see, I didn't have a discussion. I sent the email. We didn't have a discussion about rates.
Okay, let me step back for a second.
Yeah,
You signed no retainer, no engagement letter, nothing with Ms. Snyder when you were listed as an expert witness on the 17th. Isn't that right?
When I do work for the state, I don't charge a retainer. And I had sent her the rates and she agreed, and where it was the state, I don't usually don't always get engagement agreements when it's the state. Usually I just do that with private attorneys. But she agreed. I have in writing that she said that they would pay the rate, and that was good enough for me. I didn't get a retainer, so I didn't need an engagement agreement.
You know, in your deposition, you said you had nothing in writing with Ms. Snyder. You said that you didn't discuss rates with her. Isn't that correct?
If you're saying it's on there, I don't have it directly in front of me. I don't remember the context the question was asked. Obviously, if she's going to retain me, she's going to know my rates. She's not going to hire me and have no idea what I charge. That
Well,
the context of that doesn't make sense. So either it's the way the question was asked. I don't. It's hard for me to answer the question to know the whole context without what you're looking specifically at.
well, I asked you specifically, did you sign any agreement or discuss your rates with her? And you said no, didn't you?
We didn't sign anything. If you're asking me about an engagement, I don't remember the exact context. I sent an email with the rates and she had them and she agreed to them. We didn't have a conversation and there was no signed engagement agreement.
Okay.
And you never asked me at the deposition what my rates were. If you were concerned that you didn't have them, you never asked me what they were.
Well, in your deposition, you told me that you do the public defender rates and the state attorney rates and that you're on the state's list and that's how you're
You asked
compensated.
me if I had ever been, if I was on the job, and I have been, and I do that. But in this case, that wasn't the rate. I have done that. I believe you asked me about that, and I have done that many years ago. And
Well, you
so I
said you're
said
getting,
yes.
I'm sorry, I didn't mean to interrupt you. You said you were being compensated by the state rates for Miss Snyder, right?
I was being compensated by the state. I don't, the state rate, I feel like you're playing a word game with me. The state is paying my rates. That's,
So you're saying you have a written engagement or you do not have a written engagement with Miss Snyder?
for the third time, I sent an email with my rates and she agreed to it. She said that she has it, and
You have that?
if you give me time, I have, can find it. There was an email sent with the rates and she agreed to it.
Do you know when that email was
When
sent?
she first engaged me, when she first contacted me to be involved in the case.
Okay. And you're sure of that?
Yes, I'm sure of that.
Okay. Now, you have not billed Miss Snyder one penny up to now, have you?
I always bill the state at the end of the case.
Have you billed Miss Snyder one penny for your work that you've done?
I have an ongoing invoice that will be sent at the end of the case.
And how much is that invoice at this time?
I would have to look at it. I would have to look at it.
Can you please do that?
Judge, while she looks, I don't know if Mr. O'Donnell meant to help me out here, but here are the two emails where the invoice was sent to Mindy Lopez, Mr. O'Donnell, Mr. De Niro, and it was, Laura Penn was copied. One was sent July 8th, 2025. The other was sent August 15th, 2025. I know that Dr. Streyffeler also emailed because I was copied on the email, and I don't have access to that unfortunately right now, but that was more toward the beginning of this year. But just for the record, defense has those right here. I'd be surprised if they're contesting that they received the invoice at this point.
No, we received an invoice from Miss Snyder. I know that, but that's not the issue.
They had acted like they never received it, so. Just to be clear, they're not contesting that at this point?
That you paid her?
No, that I sent the invoice to them, because again, they
Oh.
have emails right here where it was sent. So if, again, on July 5th, July 8th, 2025 and August 15th, 2025. So almost a year ago.
Oops, sorry. It's on my other computer. I know it's probably, it's about, $1,500, I believe. But it's on my other computer. It's been a long time.
Wait, are you looking at your invoice for the state?
I am not. It's on another computer.
Okay, so you're just guessing that it's $1,500.
It's about that. I'm thinking of the amount of time that I've spent. And so, yes, I'm trying to give you a guesstimate. I don't have it on this computer.
Okay, so when we took your deposition, at that time, you had said you had not done any work on behalf of the state that required any billing whatsoever. Isn't that
I
correct?
object. This is outside the scope of the motion.
I'm sorry, what was the question?
At the time that we took her deposition, she had not done any work on behalf of the state, none. Just had a quick phone call, discussed nothing, and didn't send a retainer over.
It's a compound question. You got to narrow it down.
Oh, I was telling you.
But again, I don't think it has anything to do with this motion. This is about, I understand the state and they're going to get to depose her more if we can, if they pay her. And they can ask what she's done. But what the state right now owes her is not relevant to this proceeding.
Sustained, just ask if the rates are similar. You can ask that, if they're comparable or similar.
Well, I think we're entitled to know what her rates are that she's paying the state, Your Honor. Yeah.
Judge,
well,
I believe she's answered that already, that's the same.
right. We've never seen that.
But I think she answered that it's the same rates for the state as for the defense. I have that as one of her first answers to you on
Right.
cross.
We asked in deposition what her rates were that she charged the state. And she said she never discussed the rates with them. Never.
Judge, I'd like to, again, because we've had some mischaracterization of what was said.
Sustained, she's already answered. Her rates for the state are the same as the defense. That was one of the first answers. So let's ask another question.
Okay, so Your Honor, the reason it's relevant is at the time of deposition, she said she had never discussed what her rates were with Ms. Snyder. This goes directly to reasonableness. And it shows that at the time, she never told the state what her rates were. She's now saying she sent an email with those rates.
Judge, I'd
So
like
it
to-
goes to the reasonableness and the notice that we were given. We actually asked what the rates were to Ms. Snyder, and we were told, go take your depo and find out.
Okay, sustained. Let's move on.
At the time that you were listed as an expert by Ms. Snyder, you had spent no time reviewing any materials in this case whatsoever. Isn't that correct?
Objection, Your Honor, again, outside the scope of this motion.
How is that relevant?
It's relevant, Your Honor, because I don't think you had the opportunity to read the deposition. She opines that she knows nothing about this case and that she doesn't have an opinion in this case, and that I am free to ask her whatever questions I would like to ask her to find out anything that I want to know. And we asked her early on, please tell us what your expertise is that you were called and listed by Ms. Snyder for. And we were told ad nauseum, I don't have an opinion. Ms. Snyder and I never discussed anything.
You can
Okay.
answer if you need
May
to.
may I address this?
Sure.
I actually will read the email, hold on. This before the email. The reason that I know nothing, okay, this is the original email from Ms. Snyder. I am the Division Chief of Sexual Battery Unit of the State's Attorney's Office of Miami of Dade County. Assistant State Attorney Francine Deuteronomo recommended I reach out to you about testifying as an expert in an adult rape case I am handling. I need someone to educate a jury about victim behaviors. Would you have time to speak with me this week? The reason that I know nothing about this case is, as I've explained a number of times, that my expert opinion is going to be on victim behavior and not specifically on this case, and that either side can ask me any question they want about victim behavior. And that was stated a number of times throughout my deposition.
Okay, so the qualification is she doesn't have any personal knowledge and she's not an eyewitness to this case. And she doesn't have any personal knowledge because she's not the personal therapist of any of the listed victims. But so that's why she didn't know anything about the case. Do you have any other questions for her?
Yes, you weren't given the deposition of the accuser in this case. Is that correct?
That is correct.
And you only spent, according to your deposition, just a few minutes on the phone with Miss Snyder, and you knew nothing about the case.
Judge, I'm going to object. Again, this has been asked and answered. It is outside of the scope of this motion. As far as what the state owes her and the time the state has spent with her is irrelevant to this motion.
All right, you've already asked, it's already asked and answered.
Well, yes, Your Honor. And
So the objection is sustained.
well, to address Miss Snyder, Your Honor, the reason, well, it's many reasons that it's relevant. One is that she agrees in the deposition, she only spent a few minutes and there was absolutely nothing to bill Miss Snyder because she didn't discuss anything with Miss Snyder, and that she was there to educate Miss Snyder, educate the court, and educate me if I'd like to be educated. And therefore, she literally says several times in her deposition, go ahead, ask me whatever you like.
Such as a hypothetical, right?
No. What is your expertise here? I'm not here on this case. I don't have an opinion. I'm not here as an expert. I'm here to educate.
Ask another question.
So, doctor, when you were listed as an expert by the state, by Miss Snyder, to testify in a rape case by the state, you had not told Miss Snyder what your opinion would be and what your testimony would be. And Miss Snyder didn't ask you what your opinion would be and what your testimony would be. Is that correct?
Correct. My
Objection, compound question.
opinion is going to be educating the
compound
jury on.
Hold on,
I'm
hold on
not-
1 second. Hold on, doctor. Please, the objection is sustained. Just re-ask it and break it down.
Yes. When you were listed as an expert by the state, and when you came to the deposition, you had no opinion that you had told Miss Snyder you were going to render.
That is correct, because I am not rendering an opinion specifically, as I've told you numerous times. I am not rendering an opinion on this specific case. I'm explaining, as an expert in sexual violence and trauma, victim behaviors.
Okay, and let me just sidestep a second. You have never been called as an expert in a criminal trial to explain victim behavior in a sexual assault case.
I have in cases, they have not gone to trial.
You have never testified as an expert in victim
Correct.
trauma. Isn't that correct?
In trauma? No, that is not correct.
In victim trauma, in a criminal case, you have never testified as an expert.
They were settled before they went to court. That is correct.
Okay. Well, you say they. There's only one case where you only listed 6 cases where you were even an expert witness in court. Is that correct?
Yes. Well, where I've been to court a number of times with clients and as fact witnesses, but as an expert specifically, yes. Many, yes.
No. Yes, that
Yes.
you only have 6 times where you've testified in a court as an expert, correct?
2, 3, 4, 5, 6. Yes, there was a lot of crossover with the domestic and the sexual violence, and even with some of the dependency cases, but yes.
But of those 6 times, none of them were as an expert in a criminal trial, correct?
The Samsudeen was a criminal trial. Oh no, that was you're right. That was a civil trial. That is
I'm
that is
sorry,
correct.
the 6 times you were qualified as an expert that Mr. O'Donnell just referred to was an expert in what subject matter?
Let's see, I was qualified as, let's see, there's a trauma expert, a lot of it was, the victimization and trauma, a lot of it was domestic violence, specifically, the sexual violence. Although all the trauma, the victim behavior is very similar. There were, I'm looking.
Adult trauma and adult victim behavior.
Correct.
Okay.
Yeah, there are a number of cases. The only criminal cases were the battered spouse syndrome cases, and those actually, except for one, did not go to court.
And so you've gone to court once on a criminal case as an expert for the state on a battered spouse syndrome.
I've gone to court as a trauma expert. Yeah, they weren't criminal. Yes.
Only one time, and it was domestic violence, where you testified for the state that the person did not qualify as a battered spouse. Is that right?
Let me look specifically at the cases. Most of them settled before they went to court. A lot of, because of my evaluation and recommendations.
Those were battered spouse cases.
They were battered spouse and trauma cases.
You've never testified about trauma in any criminal court on victim trauma.
I did in the domestic violence murder case, actually for the defense, and that's the one that did meet the battered spouse syndrome for Angela Danzler. I'm looking, that was these others, if they went to court. The others didn't, they did not go to, they settled.
Okay, and of the 6 cases that you've listed as an expert, only one being in a criminal court, all those you were paid by the state of Florida, correct? Whether it be for a court-appointed lawyer, a public defender, or the state attorney's office, correct?
No, I was paid in the Kyle, or I was paid by the the public defender's office. That was the one in 2020 that was Jack. And prior to that, there was there was one in Henry County. They were evaluations to see if they met the criteria, and they did not, so they did not go to court. And they were paid by, those were the ones, but they were almost 10 years ago.
Yeah, it was with the public defender's office, correct?
I can't hear you.
And I'm sorry, that was with the public defender's office?
Yes.
Okay. And now we know we know that you didn't bill and haven't billed the state, but the question is, you spent less than like 15 minutes total with Miss Snyder or anyone from her office discussing anything related to this case before you were listed as an expert and before you showed up at deposition.
Objection, Judge, to relevance
You-
to this motion.
What's the relevance?
The relevance, Your Honor, is that we're being billed to have to ask her opinions that she had never, ever, it's in the record. She says, I've never discussed this with Ms. Snyder. I know nothing about this case. We had to drive to Fort Myers. We had to sit
But
down.
please don't make your arguments right now. Overruled, you could answer.
You spent less than 15 minutes total by the time that you showed up for a deposition as an expert witness on behalf of the state of Florida 2 weeks before trial, where people are facing
Objection,
15
Judge.
years in
Counsel is
prison.
Testifying.
Sustained. Re-ask the question.
You spent less than 15 minutes discussing anything related at all about this case before Ms. Snyder listed you as a witness and you actually showed up for deposition for the defense, right?
Yes, and as I've explained to you numerous times, that my expertise is in sexual trauma and victim behavior, and that my role as an expert is to answer questions related to those two things, not specifically to this case. I don't know what it is about that you're struggling to understand.
Okay, well, since you asked, usually when someone is listed as an expert,
Objection, Judge.
Right, sustained. Ask the next question, please.
so in the 4.5 hours you billed the defense to ask you questions where you quote unquote said several times throughout your deposition, I'm here to answer any questions you want. I don't have an opinion. Ask me whatever you'd like. I'm here to educate, right? And you just told me to keep asking you questions and you would answer them about
Right.
anything that I wanted to know about, right? Is that right?
That is absolutely 127% correct.
So you billed us for Miss Snyder's learning what your opinions were, because you had never told her your opinions
Objection.
before we took that deposition, right?
Objection, Judge.
Can I answer that?
Sure.
Okay, first of all, you were 40 minutes late for the deposition, so 40 minutes of that was waiting for you. Secondly, if you thought I had nothing to offer, I don't know why you thought the deposition needed to be the whole, the whole 4.5 hours, and you said that you weren't finished. And I kept explaining to you what my role as an expert, and you didn't understand it. And the fact that you didn't understand what to ask, I don't think that I need to be punished because you didn't know what to ask me. I explained my role and I explained what I was going to be testifying to. But your knowledge of trauma is such that you didn't know what to ask me, and that's not my fault.
All right, do you have any other questions for her?
1 second. And you agree that, that Ms. Snyder hired you for an education, not for an opinion, right?
Right, to educate the jury, correct.
Okay, and you had not educated Ms. Snyder about anything before you were listed as an expert, and Ms. Snyder learned 4.5 hours of your education by me having to ask you questions in the dark about what you were there for.
Well, I did not talk, I am presuming, which I know that Ms. Snyder checked out my credentials and my background and knew that I have the knowledge and the experience to answer the questions that she needs answered at trial, and that was enough for her. The deposition, what you asked, she didn't need the information that you asked at the deposition to educate her. She's a smart woman who has been working in sexual violence for a long time, and I'm sure she knows the answers to many of those questions without my deposition.
Look,
But-
you're gonna ask open-ended questions like that, you're gonna get the answer that you may not want. So you should ask tighter questions.
Your Honor, please
She's
read the deposition.
assuming things in Miss Snyder's head, which is obvious based on her answer. But
Wait,
the-
what is that?
she's assuming and presuming things in Miss Snyder's head, and she's impugning knowledge from Miss Snyder. So, but if you're gonna ask questions like that, you're gonna get answers like that. So do you have anything specific you want to ask her?
Yeah, I mean, right now, you mean?
Yes.
Yeah, you,
You just asked her if she thought Miss Snyder learned more about her knowledge and her expertise based on your 4-hour deposition. And she just went on and on and on and complimented Miss Snyder on all of her
It's fine.
experience. Okay, well, you need to ask tighter questions. Otherwise, we're probably going to be here for 4 hours.
we won't, Your Honor. So, Dr. Streyffeler, you know, Ms. Snyder told you nothing about the alleged victim's behavior in this case before you came to testify. Isn't that right?
Judge, I'm just gonna object. This is outside the scope. Again, the interaction the
It-
state had has nothing to do with the deposition itself.
Because they're
That's-
accusing you of
I get it,
basically
but-
a quasi negligent manner of hiring her, wasting their time. It's relevant to some extent. Okay, you can answer.
Your Honor, and it's not an
So
accusation.
the objection is overruled.
It's
Victim
not an
behavior
accusation. It's-
is,
She's
I
answering.
don't
Go
like
ahead. Victim behavior is.
okay, I didn't know if you said go ahead to him or me, is very textbook in a lot of ways. And and that's what that's documented. And that's what my education to the jury is gonna be, is on textbook victim behavior, ways, very common, ways that victims behave after a trauma, most specifically a sexual assault.
Okay, so you knew nothing about the alleged victim in this case or what her alleged behaviors were when you were listed as an expert and we had to depose you, correct?
Objection asked and answered multiple.
She won't
times.
let her answer, Your Honor.
She answered it. She said no.
Okay,
All right.
so,
So sustained. Let's move on.
so in other words, we could have gone into victim behavior about any case in any scenario, and you would agree that could take weeks. It could take weeks. It could take months. It could take a year of college courses to try to learn what victim behavior means. You would agree on that, right?
Of any case, I don't understand the question. Are you talking about victim behavior is very specific behavior? I don't understand what you're asking. What specifically, if you're gonna go through all your cases, there would be no purpose. There would be a thread through all of those cases. There would be a lot of the same behaviors.
You didn't know what behavior you were going to explain away
I
or
wasn't
for the
gonna
state?
explain away, any specific behaviors. I was, without knowing the behaviors in this case, I was going to explain textbook victim behaviors. Explain as an expert who's done a great amount of research and worked with many thousand victims, the way victims behave.
Okay, so you've never, none of your degrees are in sexual trauma, correct?
No, only 40 years experience, almost
But
37.
doctor, are any of your degrees in sexual experience? I mean, sexual trauma?
No, but I
Or-
do have, I've taken courses and, was certified in, I believe it was 1994 by the Office of the Attorney General as a victim service practitioner.
Okay, are any of your degrees in victim trauma
Objection.
or sexual violence?
Is any of her what? Degrees,
Any of your degrees in
victim trauma or,
victim trauma or sexual violence?
right. Do you have any
And I'm
degrees in this?
certified, but as a board certified expert in traumatic stress by the American Academy of Experts in Traumatic Stress, which is in collaboration with the National Center of Crisis Management since 2006, and I'm also a diplomat of that academy.
All right, you got a doctorate from Capella University in Minnesota, correct?
Yes,
And that is an online school that you never had to attend, is that correct?
I had to attend a number of 3 week-long residencies, and the professors that I had were not adjunct, they were core faculties. And I went just prior to when a lot of the colleges where mainstream was, where online learning was as mainstream as it is today.
Okay, and your degree in that, from that school in Minnesota was in human services, correct?
Yes, I got a PhD in human services because I had a lot of experience in not-for-profits, and I already was licensed as a mental health counselor. And so to get, I didn't want to do testing. So I chose to get a PhD in human services, which included criminal justice and counseling and homelessness and all the different areas of the human services.
Okay, so in your deposition, when you said you were just here to educate, when you were asked, what education did Miss Snyder hire you for? Your answer was, I don't know what she's going to ask me. We didn't talk about it. I don't know what you're going to ask me. We haven't talked about it. So whatever you want to ask me, that's what, or whatever she's going to ask me, that's what I'm going to educate. I don't know what the purpose, I don't know what the questions are because I don't know all the specifics of the case. So she asks me what she wants. You ask me what you want, and we'll all live happily ever after, right? I asked you to just please tell me why we're here. And this is what you continued to tell me that made us sit there for 4 hours, correct?
The
Objection,
reason
Judge, I asked-
that I said that is because I didn't want canned or pre-rehearsed answers. I wanted them to be organic. I knew she was going to ask me about victim behavior and trauma, and that's all I needed to know. I'm not going to go look up, I don't want canned answers. I want them to be organic answers when she asked me the questions. So I know that I'm going to be asked questions about victim behavior and trauma. But as far as the specific questions, I didn't need them, beforehand, because it's not like I'm gonna go look up the answers and read off a paper. I'm gonna share the knowledge and educate the jury.
So
And the same way
again,
I explained to you that I'm going to educate the jury on victim behavior and trauma. And I said to you, just like I said to her, you can ask me anything you want. You could have asked me questions like the ones you were going to ask at trial, but you didn't understand the concept, so you didn't ask me any questions. And we went round and round for 4 hours.
right. So again, right after that follow-up question, you again said, so, I've been doing it so long, you can ask me whatever you want. I don't need you to tell me.
It's been answered. All of this has been asked and answered.
Overruled.
I don't need you to tell me what you're going to ask me. I like it. I'm big on. You're kind of getting the authenticity, the integrity piece. So I didn't ask her because I don't want to know. When you ask me, then I'll answer the questions. So you just sat in that room and just kept telling me, ask me what you want to know. I don't know what Natalie wants to know. Excuse me, Miss Snyder. I don't know what Miss Snyder wants to know. I don't know anything. Just ask me whatever you'd like, Mr. O'Donnell. That's what you said throughout the deposition. Isn't that
Okay,
correct?
but if you recall, I don't know where in the deposition it is, we did go over some of the things to help you out. And Natalie did say, let me help him. I remember we went over the fight, flight, freeze and a couple of the other things. You didn't know what to ask, but I wasn't going to coach you and say, oh, ask me this. That's your job.
Okay, so this deposition was 165 pages. It wasn't until about page 90 that Miss Snyder stepped in and says, you want me to guide you? And all of a sudden,
Judge, I asked that he actually read from it. I did interrupt. It's
Yeah.
true, because it was very clear. He had not done any research, had no idea why she was there. And I did help out at some point.
Okay,
What-
just ask your questions concisely
yes.
so the witness can understand. Please, no compound questions.
Yes, I was commenting on Dr. Streyffeler's comment that Miss Snyder jumped in. When Miss Snyder jumped in on page about 90 out of 165 or 168, when Miss Snyder asked you to explain why you were there, all of a sudden you went into this diatribe that victim behavior is flight, fawn, that before page 90, you wouldn't tell me any of that. But you and Miss Snyder seem to have known what your testimony was going to be about, despite the fact that you said you guys never spoke about anything, right?
That's textbook victim behavior. So when she already knew that, I didn't have to tell her that. So she was saying that to help. You can ask her, but to guide you, I didn't have to give her that information. She already knew it. If you're educated in trauma, that's basic trauma information.
Okay, so when I asked you why you were there for 90 pages and you continue to tell me, ask me whatever you want, why is it that only when Miss Snyder jumped in that you started talking very specifically about flight, fawn?
Because
Deer in
she
the
asked a
headlights.
very specific question.
What specific question prompted that?
I don't have the deposition in front of me.
Sure.
And Dr. Streffler, you've never written a book. You wrote a book about domestic violence, right?
I've written 2 books.
One was about domestic violence, the other one was about relationships.
It's about, yes, relationships, sexuality, gender, orientation. And how to be healthy in an unhealthy world, it goes into how to have a healthy relationship.
Okay. And before you have a private client that, that hires you, do you let them know what the rates are?
Yes,
Okay. And in those 6 cases that you said that you were, maybe going to be an expert in some court, but not criminal court, your job in those 6 cases was to interview the actual person and make a clinical assessment, correct?
yes, I always explain to the attorney, when an attorney initially calls me, I say there are 2 ways I can do this. Because I can't just, kind of have some of the information. Either I interview the people, the person, and do an evaluation. Sometimes I do the evaluation first, for example, in the battered spouse syndrome, because if I don't think they meet the criteria, then I tell them that I won't, then that's as far as I'll go, and I won't, that I won't testify. But I say there's another way that I can do it, where instead of being an expert in this particular case and in the facts in this case, in trauma, in domestic violence, in sexual violence, and just in the actual trauma, sexual violence itself, that would be answering dynamics, questions related to the dynamics, but not specifically with the case. And sometimes they may ask hypotheticals. Sometimes they don't, but it's really to educate a jury.
You have more for this witness?
No, you didn't interview, so you never testified as an expert educating any criminal court before, correct?
I had been hired to do that more than once, but they were, they settled, they settled out. The Samsudeen case, I know I did, interview in that case. Let me look at the list. A lot of these were a long time ago. We're talking going back, uh, no, in these in the attorney just often wants me to do the evaluation and do it this way, and do it the more traditional way of talking to every. But that is something that I do bring up with attorneys. But I have not in criminal court, no.
You've always interviewed.
In
The-
criminal cases, I do, as a general rule. But when Ms. Snyder contacted me, she specifically contacted me asking me if I could educate the jury. There wasn't a question. I was never asked to interview the client.
How much more do you have with this witness?
2 minutes, Your Honor. I'm going to bring you back where I said it was page 90. It was page 106 when Ms. Snyder jumped in. And do you recall this, what you brought up? Ms. Snyder said, "Do you want assistance or no?" Me, I said, "What's that?" And
Say
Ms.
it again.
Snyder,
I'm sorry, say it again.
on page 106, line 7, where Ms. Snyder finally says, do you want assistance or no? And she's speaking to me, and I ask, what's that? And Miss Snyder says, I'm happy to kind of steer it if you want me to steer it. And I said, steer what? And Miss Snyder says, just ask her a question, kind of go this long. I mean, it's up to you. And I said, yeah, why not? And Miss Snyder says, are there 4 common reactions to trauma? And then you went on for pages explaining.
Because I was
Those
asked a
4.
direct question and I answered it.
But up until page 106, when I asked you why you were
didn't ask
there,
me a direct question.
when I asked you, you wouldn't tell me.
Argumentative, asked and
Argumentative.
answered.
Hold on. Did you finish answering, doctor?
Ms. Snyder asked me a direct question about trauma and I answered it. Prior to that, there were no direct questions specifically to trauma.
All right, thank you. You're almost up to the 2 minutes. Ask your last question, please.
Yes, up until from the beginning of the deposition until then, I had asked you numerous times, will you please tell me what Ms. Snyder believes that you're here for and what you believe you're here for to explain victim trauma? And you never once said to me, there are 4 common reactions to trauma, and then went to explain how simple this is and how everybody knows it and it's all over the internet, correct?
I said, I'm here. Prior to that, I said victim behavior and asked me questions.
I have no further questions.
All right, thank you. Any redirect?
Judge, no, I'm not going to.
All right. Thank you, doctor. You can stay for arguments. You can be brief. I looked at the rule. So it's a civil rule of procedure 1.390, and then you've got Florida statute 92.151, right?
Correct, Judge. Yes. And I cited those in my motion. It is my motion. And Judge, it is a reasonableness question for your honor at this point. This Dr. Streyffeler was listed as an expert in victim trauma. She was listed, she was set for deposition. As you know, in this case, I don't know that there's a single deposition that has occurred in under 4 hours in this case. Maybe we had a couple at 2. But the fact that this is a 4.5-hour depo is not uncommon in this case. I will say defense came to the depo. He was unprepared. He had done no research. He did not have any real questions. He was, again, 41 minutes late. The questions that he asked were very broad. They were not tailored at all to her area of expertise. Judge, she does have, she is an expert. I understand that there are limited cases where she's actually testified. First of all, I want to point out that if an expert witness can be called just to educate the jury. And in cases of sexual abuse, it has been found that if I gave her, say, the victim statement or had her evaluate the victim, she was then called to testify regarding that. It would be an expert in the credibility of that witness, and that is not permissible because you cannot have an expert opine on the credibility of a witness. So in sexual abuse cases, I believe in the federal case, in fact, we call experts to talk about specific patterns in trauma and in victim trauma without having the person specifically interview or evaluate the victim at hand. Dr. Streyffeler is right. I've been doing this for a long time and I know the common victim trauma responses. I cannot testify, however, so our conversations beforehand were brief. However, that doesn't mean she is not an expert. By any means. She has had 40 years working with victims of sexual assault, and domestic violence. And I will say the trauma responses for domestic violence and sexual assault are very similar. As are, I know she's testified as an expert in battered spouse syndrome. Battered spouse syndrome does relate to trauma responses. So she has definitely testified about this before. She is, and she's definitely experienced it. She's taught at Florida Gold Coast. She knows this area very well. and she's qualified as an expert. As far as her rate, it is her rate for all cases currently. It was given to me. I was never directly asked for the rate. I understand they sent that one email that had a laundry list of questions. It read to me more like they were asking for a proffer about what she was going to testify to. And my response was, I provided everything as required by 3220, which I had at that point, which I gave them her CV. So they were well aware of what her background was
You
in.
did provide her CV?
I did. I provided her CV. I provided what she was being called as an expert in. And her CV is pretty lengthy, Judge. To me, I read that and I knew exactly why, we would be calling her.
And she was going to be called by the state of Florida as an expert in?
Yes, as an expert. Let me pull the actual, hold on.
Her testimony was she was hired as an expert in victim trauma.
I believe, I forget how I listed her, but it was a lot, Judge. And again, I provided her CV. I think it was pretty clear to me, at least, and anybody who had done their homework prior to the deposition, what she was being called to testify to. Or at least, a lot more than, hold on. I don't have it right in front of me, Judge, but I did list her, and again, I provided her CV. So Judge, as far as the rates, her rates are reasonable, considering her 40 years of experience concerning, other experts in this area. I understand defense decided to be 40 minutes late and not really have direction as far as what they were going to ask. But that's not the witness's fault. And that's not my fault. Usually when you come to a depo, you have questions, pointed questions that you're prepared to ask. And certainly based on her CV, which I did send to Your Honor, I believe on an email with defense copied. Certainly, I think it's very clear as to what her area of expertise is in this case. So, Judge, I ask that you grant the state's motion to compel payment and order the defense to pay Dr. Streyffeler the amount that she asked for. Your response.
Yes, Your Honor. In deposition, Dr. Streyffeler testified that she never told Natalie Snyder her rates. It's in the deposition. It's in the record. I believe it's part of our attachment. Okay. We tried to get her rates from Ms. Snyder. Ms. Snyder, you can couch her response however you want, objective or however you want. Ms. Snyder's response to us was, "You are welcome to depose her. I have provided everything I'm required to provide under the discovery rules." She did not write any reports. Ms. Snyder says that we show up unprepared. We asked Ms. Snyder on the eve of trial of Mr. Fisherman, when this expert was filed, without any idea what this expert was going to testify to. That's what Dr. Streyffeler's deposition says, that she has no idea what she was going to testify to about a particular victim behavior. When we asked, "Natalie, please provide us with the subject matter on which Dr. Streyffeler is expected to testify." Ready?
Did they respond to you?
Yes,
What the subject matter was?
her answer was, "You are welcome to depose her." I'm going to refer to that answer.
Did she identify in discovery?
I did, Judge, and I
And what
don't
was-
know if the clerk has the discovery exhibit. I can look.
Does the defense have it?
Yes, it's in our motion. She listed an expert witness, and by the way, she listed the expert witness
What?
as victim trauma or something to that effect.
Right.
So she also listed Dr. Streyffeler as a witness who had spoken to somebody in the case. So we needed clarification on that.
I'm sorry, just so I can put it on the record. Expert in psychology and trauma.
That's what I listed. Yes, Judge, that sounds right. I just wanted to thank you.
Psychology and trauma on the eve of trial on a case that where the alleged assault happened over 8 years previous to this. So then in deposition, we're met with, "I'm here for explain behaviors." Well, there's 8 years of behavior, Your Honor. There's 8 years of behavior that the state is apparently calling this doctor to explain away. but they won't identify. They being, because I don't know, Dr. Streyffeler said she had no information about the case at all. So we're to come in here in the deposition room and just start saying it. Doctor, tell us everything that you know. What do you mean ask you a question? You can go through it at least 5 times. You go, ask me a question. Oh, that question is too broad. Narrow it down. Ask me a question. She wants me, the state or the doctor wants the defense to try to figure out what she's going to testify about something that happened 8 years ago, and whether it's behavior from 8 years ago or all up until the trial, or even her testimony at trial. We won't be told. So in order to narrow it down to go take this deposition, we asked her, please provide us with the subject matter on which Dr. Streyffeler is expected to testify. I'm going to refer back to her answer. You are welcome to depose her. I have provided everything I'm required to provide under the discovery rules. Didn't write any reports. The next question. Give us a summary of the facts and opinions as to which she is expected to testify. I refer Your Honor back to the same answer. The other question to try to help us so we can take a proper deposition, to also give us the grounds for each opinion. Again, the same answer. You're welcome to depose her. The compensation for her services. Again, you're welcome to depose her.
I can tell you right now, that line about the compensation for the services is not clear, considering it was part of what looks like a compound question. I'm not being nitpicky, but I'm opening it up to you in the event that you want to clarify for me.
Thank you.
Is that because I saw the email? So I'm just letting you know, the compensation part is not compelling at this stage based on your arguments and based on what I'm reviewing.
Well, Judge, if this was a question in a court of law, you could say it's compound. These are lawyers defending a rape case with commas, grammar, and
That cuts both ways.
okay, we are
You're lawyers, very experienced lawyers, very well-prepared lawyers. You want me to believe that you had no idea what this witness would charge your clients?
well, we were told she's on the jack rates in the depot.
You're very experienced lawyers. You have me believe that when you go up to New York and help out on that case, you're not aware that in the New York case, the federal government put on a witness regarding victim trauma and was allowed to explain it to the jury, right?
Yes, Your Honor, that's a federal case.
Right, but
That's the law is completely different, but that took place well after this deposition.
it cuts both ways.
But it,
You all have accused in the past the state attorney's office of working in concert with the federal AUSA office. What are you really surprised that the parallel prosecutions would be similar, different?
that's a different issue, Your Honor. That trial in New York that we just observed from the stands, we were not attorneys of record on that case. Ms. Snyder did follow it very closely, and she wants Your Honor to rule. She actually said she's going to provide that motion. Highly inappropriate. She's providing.
Have been given transcripts from, I think, the bond hearing in federal courts. I think they're equivalent of a pretrial detention hearing. And when we had arguments on the alibi witness, the alibi issue with Mr. Sloman's client, the drone, I was provided by Ms. Zalharban some transcripts from the hearing regarding what was on the electronic devices, because there was a staleness issue. My point is, there's enough in the record of some overlapping between state attorney and the federal government. Your defense of your clients, as well as the federal attorneys of record in federal court. My point is, it cuts both ways.
Well, if we're talking about admissibility, I think it's highly improper for Ms. Snyder to try to submit case law from federal government to allow you. There's law that's very clear. This is the Florida courts. We do not follow the federal rules. We follow the state. And it is inappropriate to try to persuade you with that when the law we think is contrary.
I can appreciate that.
But that's,
At face value, there'd have to be a Daubert motion, right? In order
Yes.
for this expert witness to be allowed to be to testify before a jury and quote unquote educated jury. I get that. Yes.
so the novelty, forget the federal case. So that's why I'm concerned about the federal case seeping into this, because is it reasonable to list an expert witness and not know anything that they're going to testify? The state did that. If we did that, we would maybe be disbarred. Okay. We would maybe be disbarred or certainly ineffective assistance of counsel. Never seen it done before, quite frankly. Never. But, and I'm not making an accusation, but this witness was listed very hastily with no knowledge, no paperwork, no agreement. And according to her deposition testimony, not even discussing what the hourly rates were between the state and this expert. And Your Honor, the state argued that the defense needed to take a defense continuance and waive their speedy trial to take this deposition, this expert. Maybe that's just a coincidence. Maybe they waited, to the eve of trial to list this expert, in trial prep.
What are the rules of service? Isn't it 5 days? You list a witness, you're
An expert witness, though.
you're technically, if everyone is working on the only case that's in front of them, 5 days is sufficient. The reality is courts will give more time. So.
Well, I think it will be a state charge continuance, as it should be, but that's a whole nother matter, Your Honor. But we tried to get prepared for this. We were told,
look, I get where you're coming from. They listed the witness quickly. The witness, in your opinion, didn't have any poignant opinions. There were generalities, again, in the words of the doctor, to educate the jury on trauma. How is that unreasonable? Objectively speaking, how is that unreasonable?
but what trauma? She doesn't know the accuser. She doesn't know what trauma.
Talked about being able to educate, but also if you gave her hypothetical situations, she may be able to explain victim behavior, especially victims of sexual violence. Okay, I'm inclined to grant it. Is there anything else that you want to tell me
Yes, there is,
in
Your Honor.
addition to what you've already argued?
Yes, we also asked for the percentage of cases which he has testified for victims of sexual abuse. And you know the answer. We were told to depose her. So inherently, and I think unfairly and not reasonably, we were sent in to take a deposition where we knew nothing intentionally. Ms. Snyder could have easily said to us, she's going to testify about these 5 things that she jumped in on. Ms. Snyder jumped in on page 106 out of a page 158, I think. Or I don't know if it's 158. So that could have easily been done, but it wasn't. And we weren't told any rates. We weren't told what the bills were. Ms. Snyder, according to the depot, was never even told. We would like that email where the rates were sent, because we are entitled to know what the rates and agreements were. And it's contrary to what was said in the deposition. We were told that Ms. Snyder and Dr. Streyffeler never even discussed their rates, much less also said our rates. So I think that's very important. So Dr. Streyffeler, as we know, has never, not once, ever been a witness in a criminal case that relates to anything related to this. Not one time. Never. She's only been an expert in a criminal case once in her life. She doesn't even recall which case it was, whether it was the state or the defense. But that's how long ago it was, she said, and insignificant, I guess. I don't know, but it was a domestic battered spouse syndrome. Earlier in her testimony today, she said it was for the state, then she said it was the defense. But either way, one time in a criminal case and nothing to do with the subject matter that the state is proposing. And the reason, I know this isn't a Daubert motion, but it's highly relevant to the rates and the reasonableness, including that we were told nothing going in there about alleged victim behavior, I mean, there's so much behavior on the accuser in this case that, I mean, we could still be here asking questions about it. But the doctor didn't know anything about it intentionally.
All right. So over your objection, the motion compelling payment is granted. Just because at this stage compensation is required doesn't mean that I would have allowed her to testify at trial. We never got to that point. I think she is listed against your clients, but Mr. Sloman's client's case was dismissed. What I heard was that she's been a mental health counselor since 2008. She has a bachelor's, master's, and PhD. The PhD is in human services. She's been in private practice since 2012. Expert witness for guardian ad litem. She's also an expert in battered spouse syndrome and also in abuse counseling and treatment. She's board certified in traumatic stress. She was hired by the state of Florida last year as a witness for victim trauma. She's been qualified 6 times as an expert in trauma and victim behavior, although never testified in court specific to sexual trauma, not from what I heard. If I'm wrong, someone can correct me. She has been hired on those types of cases, but her testimony is they never went to court. They were resolved or pled. Her rates that she testified to were unimpeached regarding the comparable rates in her jurisdiction, which is on the West Coast between $300 and $500 an hour. She asks a rate of $400 for court appearances and $350 for non-court appearances. The $21.50 was accounted for regarding the hours of the deposition as well as the travel time. There was some confusion about whether or not the deposition should have been done in her office. It looks like it could have been done, but considering that she doesn't technically have a conference room, I don't fault her or the state for suggesting it be done in a larger place than in her office. So the rates are reasonable. The hours that she's asking for compensation are reasonable, and she is qualified as an expert under the law. That's the justification in summary for granting her the state's motion. Here's an order. It asks for compensation to be made within 15 days. Right? Feel free to make a copy of that.
Your Honor, can we make this part of the record, the emails? And also, Your Honor, I'd like to just add, I know you're on a rule, but you know, the fact that Dr. Streyffeler may be an expert, any compensation needs to be tied to what her expertise will be in this particular case. And it's unprecedented. He's never been an expert in it. I think that Your Honor should consider that.
Hired as a witness for victim trauma.
And she's never been an expert in that.
She has been hired as that, never gotten a chance to be qualified in court or testifies to that. She discussed testifying 6 times as a witness in trauma and victim behavior.
Your Honor, I don't think that's accurate. None of the cases were criminal in nature, and they were all domestic cases.
Your objections are noted for the record.
Yes, Your Honor, I'm just clarifying.
Understood. Anything else?
Judge,
Yes.
they want to mark this as evidence?
The email as an exhibit.
Yeah, that's what I meant. They want the email as evidence?
Correct, right. The email as an exhibit.
Your Honor, can
Is
you put
evidence for
30
this hearing.
days on it instead of 15?
Why?
Just because we have,
Last year, there have been no objection raised prior to, the final motion, so I don't.
because the state has hired her and haven't paid her a dime yet.
15 days is what was suggested. That remains.
Yes, Your Honor.
Anything else? All right, looks like we're gonna see each other on 8/21, correct? 8/21. We'll keep those dates. Thank you. Last case on calendar, I'm gonna go off record.